Hello, my name is Chelsea G. Today I'm going to be talking about the history of special education law in the United States and highlighting several important historical judicial decisions. This resource is created for parents and guardians of students with disabilities. Let's begin with a brief history of special education before the 1970s. Now, before the 1970s, students with special needs didn't really have a lot of options, very slim possibility of excelling in free public school systems alongside children without special needs. The definition of special education has changed throughout the time, with its beginnings dating back to 1954. In the court ruling of Brown versus Board of Education of Topeka, it was ruled that segregation violated equal educational opportunity. While this ruling was made in response to the unfairness of racial segregation, it developed a broad understanding that everyone deserves equal access to a good public education. The Elementary and Secondary Education Act was revised in 1966 to offer federal financing for public education for students with disabilities. The 1970s saw more substantial improvements in special education students' lives than any previous decade in the field's history. The Pennsylvania Association for Retarded Children versus Commonwealth of Pennsylvania, which is PARC, and Mills versus Board of Education of District of Columbia cases were catalysts for change. PARC focused on the exclusion of mentally disabled students from public schools. Following the settlement, it was decided that school placement decisions must include a process for parental input and a method for resolving disagreements. Mills involved the practice of suspending, dismissing, excluding disabled children from public schools in the District of Columbia. The ridiculous cost of educating students with disabilities was the school district's main justification in Mills. Following Park and Mills, Congress initiated a study into the plight of disabled children, discovering that millions of children were not receiving an adequate education. After many major court victories affirming the right to education for all disadvantaged children, legislation was committed in Congress in 1972. The Rehabilitation Act of 1973 gave all disabled individuals legal rights and mandated that disabled kids be accommodated in schools. The Education for All Handicapped Children Act, which is HEA, was passed in 1975, guaranteeing and enforcing the right of children with disabilities to free and adequate education. Raleigh versus Hendrick Hudson School District was the Supreme Court's first interpretation of the Education for All Handicapped Children's Act. That was enacted in 1982. According to the court decision, kids who qualify for special education must get specialized teaching tailored to their specific requirements. IDEA was amended in 1997 to guarantee that students with special needs have access to meaningful, quantifiable programming. It also increased parents' participation in creating their child's individualized education program, which is IEP. The No Child Left Behind Act of 2004 increased state-level special education systems by requiring statewide assessments and highly competent, specially trained personnel to teach students with disabilities. While this act contained certain contentious elements, it was repealed in 2015 by the Every Student Succeeds Act, which corrected many of them. Here are the recommended resources to help parents stay up to date with the current legal special education trends. My first resource here is the Ohio Department of Education. That's at education.ohio.gov in topics special education. I also have a resource for the U.S. Department of Education as well. That's the Office of Special Education and Rehabilitative Services website. And the Special Education Toolkit resources website, which is pta.org. Thank you. Have a great day.